Hi there. In this video, we are basically going to be looking at jurisdiction, and specifically, we're going to be looking at civil jurisdiction of courts in Uganda, and our emphasis is going to be looking at the Supreme Court, the Court of Appeal, and the High Court. Hello there, my name is Mutiaba Conrad. I'm a lawyer and a private law tutor. And before we start on our class, I encourage you to ensure that you have fully subscribed to my channel. Just click on the button just below there. Also turn on your notifications so that every time I release videos, this is brought to your attention. And then also students interested in our private law tutorial sessions, please reach out to us. Our numbers are down in the description box. You can always contact us either by WhatsApp or by a call or a text message, and we'll be able to help to tutor you privately, and this will really help you improve your grades. And we can always do this in the comfort of your home or office or anywhere that we come to an agreement. So before we start on our class, like I told you earlier, we're going to be looking at the jurisdiction, the civil jurisdiction of courts, and we're going to be looking at the Supreme Court, the Court of Appeal, and then we'll also look at the High Court. So let's jump right into it, and we're going to start by looking at the definition of what amounts to jurisdiction. So basically, every time we talk about jurisdiction, what here we mean is simply the power of court to hear or try a matter. So what power does court have, okay, to hear a matter or to try a certain case? That is all simply that jurisdiction is about. So that definition can actually be found in the case of Mukasa versus Mwanga, that is HCMA number 31 of 1994. This case is unreported, but at least court attempted to define jurisdiction as the power of a court to hear or try a matter. So let's now proceed to look at some of the principles governing jurisdiction before we jump into looking at the jurisdiction of the Supreme Court. So jurisdiction, one of the fundamental principles that you have to know about jurisdiction is that jurisdiction is not implied, okay, but rather it must be prescribed by law. So you just can't assume jurisdiction, okay? You just can't assume it. It can't be implied. It must be expressly provided for under the law. And here, when we talk about the law, what we mean is the Constitution or an act of Parliament or case law. Okay, this is really very, very important to note, and court couldn't overemphasize it in the case of Athanasius Chivumbi Rule versus Honorable Emmanuel Pinto. This is a constitutional petition number 5 of 1997. Court stressed that principle, and it is very important as a student to know the same. Now, the other fundamental principle governing jurisdiction also is the principle that proceedings by a court without jurisdiction are nullity. Now, this is very important to note. Whenever a court hears a matter where a court does not have the jurisdiction to hear such a matter, the same is a total nullity. It is a wastage of time. It is a mere tea party. Jurisdiction is so important that it cannot never be ignored. And whenever court hears a matter without the required jurisdiction as stated under the law, then the judgment and the decision of court is a total nullity. And this has been emphasized in so many cases, including the locus classicus of Winnie Byanyuma versus Ngomangine, and also the case of Desai versus Wasama. It's a case of 1967, East Africa, page 351. Now, the other aspect to also note about the jurisdiction is that a court is only competent if it derives its power from law and if it's properly and duly constituted, okay? So the people who man the court, okay, must be properly appointed. This is very, very important. And authority for that position, please look at Article 142 and 143 and Article 144 of the 1995 Constitution of Uganda. So this is really very important. It cannot be said that a court has power to hear matter unless the judges, okay, are properly appointed. This is really very important to note. And then, of course, factors that determine jurisdiction also include, for example, the value of the subject matter, Okay, so when we are talking about jurisdiction, other aspects that we mean, one is the value of the subject matter, okay, in contention. Here, what we mean is that the issue that has brought you to court, if, for example, you're disputing the ownership of a certain house or premise, so we look at the value. Is it worth 100 million? Is it worth 20 million? Okay, so that also pertains to jurisdiction. Okay, the value of the subject matter. Then also the geographic location, okay, where the cause of action arose, among others. So these are some of the aspects that we'll look at whenever we are talking about jurisdiction. Now, having laid down those fundamental principles governing jurisdiction, ladies and gentlemen, let's now proceed to look at the specific jurisdictions of these courts. And we're going to start with the Supreme Court, and let's look at the law. First of all, it's important to note that the Supreme Court is established by Article 130 of the 1995 Constitution of the Republic of Uganda, and then also Article 131 provides that the court is duly constituted if it consists of an uneven number, not being less than 5 members of the court. However, when hearing appeals, whenever this Supreme Court is hearing appeals from the Constitutional Court, then the court shall consist of a full bench of all members of the Supreme Court. This is really very important for you to note. And then also under Article 132, it is the final court of appeal, and it has appellant jurisdiction from the Court of Appeal. What this in essence means is that it hears appeals from the Court of Appeal. The Supreme Court also has original jurisdiction when dealing with presidential election petitions under Article 104 of the 1995 Constitution of the Republic of Uganda. And also the Supreme Court of the Republic of this country has also emphasized this in the case of retired Dr. Kizza Besigye versus Yoweri Kaguta Museveni and another. That was election petition number 1 of 2001, that the Supreme Court has original jurisdiction when dealing with presidential election petitions. Now, every time we say original jurisdiction, what we mean is that a matter can be started in that court. Okay, original jurisdiction means that a matter or a case can be started in that court. Let's now proceed to look at the Court of Appeal, and we look at the law and the jurisdiction that it has. And of course, the Court of Appeal is established by Article 134 of the Constitution, and also Article 135 provides that the Court of Appeal is duly constituted at any sitting if it consists of an uneven number, not being less than 3 members. So the number must always be uneven, and the minimum composition is 3 members of the Court of Appeal. And then also of interest to use Article 134 Clause 2 and also Section 10 of the Judicature Act, which gives the court appellant jurisdiction from the High Court. So meaning that the Court of Appeal hears appeals from the High Court. Okay, very important there. Then also of interest to you is Section 145, subsection 3 of the Local Governments Act, and this section gives the Court of Appeal appellant jurisdiction from the High Court on parliamentary and local council election petitions, and its decision shall be final. Now, this is very important to note that the Court of Appeal is allowed under the law to hear appeals, okay, of parliamentary election petitions and also local council election petitions. These are LC3s, mayors, and so on. So it can hear it. And actually, the Court of Appeal, interestingly, is the final court in parliamentary and local council election petitions. Now, most people actually do not know this. You cannot appeal the decision or a case which pertains to election petitions in members of parliament or local council matters to the Supreme Court. The Court of Appeal is actually the final court of appeal in those matters. Then also of interest to you is Section 12, subsection 1 of the Judicature Act, which actually allows a single justice of the Court of Appeal to exercise power of that court in any interlocutory cause, and where a party is dissatisfied by that decision under Section 12, subsection 2, the matter is determined by a bench of 3 justices of the same court. Now, this is very important to note. Please go and look at the case of Lukwago versus Attorney General, Supreme Court Civil Application number 6 of 2014. Very, very, very important to note there. Let's now proceed also, and of interest to you as well is Article 137, Clause 1, which states that while sitting as the Constitutional Court, the Court of Appeal has original jurisdiction in matters of constitutional interpretation. So here, in essence, what we are trying to say is that in matters of constitutional interpretation, it is the same Court of Appeal that actually transforms itself into the Constitutional Court, and it has original jurisdiction to hear all matters pertaining to constitutional interpretation. Now, also important to note is that the Court of Appeal also has appellant jurisdiction from decisions of the Industrial Court, and authority for that position can be properly found under Rule 23, Sub-Rule 1 of the Labor Disputes Arbitration and Settlement Industrial Court Procedure Rules of 2012. Very, very, very important for you to know there. Let's now proceed, ladies and gentlemen, to look at the civil jurisdiction of the High Court. And of course, the High Court is established by Article 138 of the 1995 Constitution of Uganda, and also Article 139, Clause 1, and also Section 14 of the Judicature Act gives the High Court unlimited original jurisdiction and also appellant jurisdiction from lower courts of law. Please look at Section 16 of the Judicature Act, which further gives the court appellant jurisdiction. And also, of course, of interest to you is Section 220, subsection 1A of the Magistrate Courts Act, which gives the High Court appellant jurisdiction from the Chief Magistrate Court and also the Magistrate Court Grade 1. So this is really very important for you to note that this High Court can actually hear appeals from the Chief Magistrate and Magistrate Grade 1. Let's now proceed to look at the various, just for, for your own benefit, it's important to note that the High Court is actually divided into High Court circuits. Okay, and some of these circuits include, for example, the Commercial Division, and this was established by the Constitutional Commercial Court Practice Directions, Legal Notice number 5 of 1996, paragraph 4, clause 1. And then also the other division in which the High Court is divided is the Family Division. There's also the Land Division, and there's also the Civil Division. And of course, this handles civil matters. Then also there is the Execution and Bailiffs Division, which was established by the Administrative Circular number 4 of 2011. So those are some of the circuits within which the High Court is established. It has some of, you can call them branches where certain matters can be lodged. So if it's a civil matter, then you must institute it in the Civil Division. If it's a land matter, it's good practice that you should proceed to institute it in the Land Division. If it's a commercial matter, then institute it in the Commercial Division. But it's also important to note that these circuits are really mostly in urban centers, especially in Kampala. But then when you go a little bit out of town, these you really find only one court. It is not very common that you'll find these circuits. So let's proceed, ladies and gentlemen, to look at the civil jurisdiction of the High Court. And also of interest to you is to notice that the High Court can hear matter meant to be heard by a lower court. Now, a situation really can arise where a High Court can hear matter which ordinarily should actually be heard by a lower court. Okay, so it's possible. For example, a matter can be maybe its pecuniary jurisdiction is about 40 million, but it can still be heard by the High Court, and that is the position of the law. I interest you to look at Section 11, subsection 5 of the Civil Procedure Act, Cap 71, but also the case of Munyangwa versus Lucy, okay, Kamujanduzi. It's a case of 1972, East Africa, page 332, and also reported in HCB, page 117. That case was authoritative, stating that the High Court can hear matter which ordinarily should be heard by a lower court, or even a Chief Magistrate Court can hear matter which ordinarily should be heard by a lower court. The effect only really comes in the costs, and the position of the law is that costs will not be awarded, okay, to the party who instituted that matter in the High Court, whereas actually under the law it should have been properly heard by a lower court. And then also in that case which I just shared with you, court also established another important principle, which is that jurisdiction of the High Court in civil matters is unlimited. This is very, very important to note. So the jurisdiction of the High Court in matters of a civil nature is actually unlimited. There is no limit. It can hear any matter worth any amount. For example, it can hear a matter whose pecuniary jurisdiction is 200 million or even a billion shillings or even a trillion shillings, whatever the case. Please, let's now proceed to look at quite another important principle, and that is that the High Court only has appellant jurisdiction in matters of tax disputes with URA. And of course, the authority for that position, I interest you to look at the case of Uganda Revenue Authority versus Rabo Enterprises Uganda Limited. This is civil appeal number 12 of 2004, and basically in that case, court was stating that in matters of tax disputes with URA, the High Court only possesses appellant jurisdiction and not original jurisdiction. So the Supreme Court was in essence trying to say that when you have a tax dispute pertaining to a tax levied by URA, the first court of instance should actually be the Tax Appeals Tribunal, and that you should appeal to the High Court where you are dissatisfied. So it's not good practice for you to run straight to the High Court. It would be advisable that you first go to the Tax Appeals Tribunal. Let's now proceed to look at another aspect pertaining to jurisdiction, and this is that the High Court has jurisdiction over arbitration agreements. So it also has power to hear matters of arbitration agreements. Authority for that position, I encourage you to look at Section 6 of the Arbitration and Conciliation Act. It is authoritative on the same. The other principle, again pertaining to the jurisdiction of the High Court, is that the High Court does not have original jurisdiction when hearing applications arising from arbitral awards, and authority for that position can be found in the case of Babcon Uganda Limited versus Mbale Resort Hotel. This is civil appeal number 6 of 2016, and basically the Supreme Court was saying that the High Court actually doesn't have original jurisdiction when it's hearing applications of arbitral awards. Okay, so this is really very, very important to note. Normally people tend to think that it does, but according to the Supreme Court, it does not have such original jurisdiction. Let's now proceed to look at another principle pertaining to the jurisdiction of the High Court, and this is that the territorial jurisdiction of the High Court is limited to Uganda. Please, this is really very important to note. The only exception is where there is an agreement to the contrary. So if there is an agreement to the contrary, then the jurisdiction of the High Court can actually go beyond the jurisdiction of Uganda. But without that, if there is no agreement stating so, then the High Court cannot hear a matter which has especially that international or cross-boundary element. The other important principle as well pertaining to the pecuniary jurisdiction of the High Court is that the pecuniary, when we talk about pecuniary here, what we mean is the monetary. Okay, so the monetary jurisdiction of this court is actually 50 million, meaning that it can hear any matter whose monetary value is in excess of 50 million shillings. That is also important to note. Now, also, for you to note really on the jurisdiction as well, is that this High Court has jurisdiction to hear matters with an international element if the agreement so provides. So if you have a matter, let's say it's a contract, the contract has an international element, the High Court actually has powers to hear such a matter, and this is the position of the law, and I encourage you to look at the case of Laco Concrete Products Limited versus Transair Limited. It's a case of 1987 HCB page 40, where that principle was stressed and emphasized by the court. So basically, when we talk about the civil jurisdiction, ladies and gentlemen, that is what we actually mean. And whenever you find that question, please feel free to look at it from that perspective. So basically, that was it for our class today. Again, I encourage you, if you're a student, if you're a researcher, and you need private law tutoring, you may have challenges in civil procedure or any other course unit, please feel free to reach out to us. Our numbers are down in the description box. Just call us and we will be able to give you these private law tutorial sessions. Also, do not forget to subscribe to this channel, like and share this content in case you love it. And subscription is really very important, and also ensure that you turn on your notification, because every time we release videos, this will always be brought to your attention. So thank you very much for listening in. We meet again in another class. Bye-bye.